Next, I want to invite Diserams and Nitya partners. Take a few minutes to sort of look at any new. You want to shed new light to this. Anything that was not discussed thus far.
Nothing new from Niti Partners, nothing new to discuss because the concerns that we had about the competence of the infrastructure to handle this new law has been raised and dealt with. So nothing from us at this point. We'll give the time to someone else.
You are from
Niti Partners.
Nitya. Diserams, you have anything to add?
Hi, we were instructed by the Sri Lanka Bankers Association to review the draft act in a very early stage of its development, and we prepared a comprehensive report on where we think it needs revision. I don't know whether really we haven't had much time to look at this one.
But just one moment.
Yeah.
He said that there is hardly any difference between what you looked at and what's now.
So then that means none of those amendments have been incorporated. So we would like to make comment on this draft bill, if there is time to do so. Yeah.
Nobody retained you this time.
No.
Unfortunately for you. Right. So, I mean, you are saying that
Can you submit that?
So that's
observation.
we can.
So what you are saying is you had certain observations, and what you're saying is none of those have been incorporated in
Yes.
here.
So to be honest, we haven't looked at the draft bill in its present form.
Okay.
So we don't know whether our amendments proposed 2 years ago have been incorporated. But if Mr. Chanaka De Silva said that it hasn't undergone much revision since it was first drafted, then very unlikely. So we would like a few days to review this version and comment.
Yeah. Can I make an observation?
Yes, please.
The draft went through several iterations, and those iterations went through stakeholder comments. And many comments that were made by stakeholders were incorporated into the final draft, which was presented in February. So I am not sure whether any comments that were made by the bankers, if they were made, now what...
Your client was the banking association.
Yeah.
Yeah, so they are here.
Yeah. So if they were made, they might have been addressed, because we went through all the comments that were made by stakeholders. Some were accepted, some were not. And the final draft is what has not changed then.
So could I please ask the Bankers Association to sort of address that and any other issues that they may have that have not been discussed thus far? Miss Himali Mudadenia and Miss Varuni Egodage.
Actually, Chairman, through Diserams, Bankers Association made representation and made that we need certain amendments. Actually, we did not get time because we were informed of this meeting only yesterday evening. So we
Sorry, are you from the Bankers Association? Or
no, I'm representing the Bankers Association today. I'm the head of Legal Commercial Bank, Varuni Egodage.
So did you see the gazetted bill before you, because this was gazetted some time back?
Yes, no.
This was gazetted in March.
Yeah.
Yeah, but I don't think the banks have reviewed it since.
So then that's, yeah.
I mean, the invitations went last week. I don't know why people are saying you all were told yesterday. I don't know. I'll check with the. Strange.
So there's no written submission from Bankers Association, no? It's just that, no.
I mean, if there are, this is the time, because once, there is no post-enactment legislation, review.
but this has already been gazetted and it has
Yes,
been there in
yeah.
the public domain
Public domain for some
So the-
time.
Yeah, if that.
I mean, people who are
2 weeks is
interested should
also
have looked at it.
counting from when, after presenting in the parliament, there will be 2 weeks to the
Yeah.
review, right?
Yeah. This is
Still there is
presented in
time.
Still there's time, yeah.
Has this been challenged in the Supreme Court or something? No. No, it is not. So then, yeah. I don't think there are any public.
Can we know the date to make the submissions?
So
No,
this
so the
is-
parliament, this will be presented to the parliament.
When
for the
would that
second
be?
reading.
That is 5th.
No,
Fifth.
so this
Oh, we
was-
debated on the 6th.
Yeah,
This
it will
has
get
been-
debated on 6th, but then there is room until it get enacted.
Okay.
So there's provisions in the
No,
law.
but- no, but
You're
this is-
making a mistake, Honorable
This is part
Chaturanga.
of the
This is a
second
second reading.
Oh, they can say-
Yeah.
Second reading is on Wednesday. So if Wednesday, if this gets approved, Speaker signs, it becomes law on Thursday. So I mean, so therefore, if any amendments, you should immediately write to the MOJ. The secretary is here because it will be the MOJ that will be making any amendments during committee stage, and we can assist the process. But it's through the MOJ that you have to go. Yeah, 2 period, yeah. So if the Bankers Association has nothing more to add, what I'll do is now we'll move to the chambers. Can I ask the National Chamber of, is the Ceylon Chamber also here? Ceylon Chamber and the National Chamber. Would you be willing to make some observations?
Honorable Chairman, I represent the Ceylon Chamber.
Yes.
Yes. Yeah, this is an ambitious law reform, and this creates the rescue mechanism. Although this creates the rescue mechanism in terms of if you consider the rescue financing mechanism, we don't see many provisions on that. Now, especially when you are going through the rescue process, if rescue lenders are not adequately protected by way of the priority, the entire rescue process may fail. So if you consider a process like a model like Singapore model, IRDA, so it gives a well-structured protection modality for rescue lenders.
Just one moment, let me interject here. There is no way to restructure this piece of legislation, this law. This law is done. You know, I mean, here the objective is to take it and see whether we can tweak it this way, that way, so that we can make it better. So we can't go back to the drawing board. I just want to make that comment.
Yes, but if, now certain things can be addressed at the when you are drafting the regulation, but there
Sure.
can be, but things like the protection by priority, I'm not sure whether it can be addressed at the regulation level.
No, but then that
Thank
we
you.
discussed, no? That we discussed, and basically I think, you know, both Mr. Jafferji and Mr. De Silva sort of had their, say, and I think what Mr. De Silva is trying to explain is that, you know, they are only prioritizing the taxman for 1 year, and then after that he also has to come in queue. So the sort of the equal treatment of all creditors, like Mr. Jafferji mentioned, I think to an extent is addressed there. So because I don't think you can change the law, you know, and that's not our objective either, right? Just to get some additional feedback whether we can tweak it, that's all.
Thank you, Honorable Chairman.
I didn't mean to cut you off. I mean, you know, I just want to make the comment that,
Yes.
you know, we can't get to the fundamental building blocks of this law. Yes, Mr. De Silva.
With regard to rescue financing provisions, there are rescue financing provisions in the law, because that is something which is very important. Like I told you, nobody is going to give funding for a distressed company or distressed entity unless they are going to stand in priority. If they are going to stand in the normal queue right at the back of the queue, they are not going to come and give you money. So that has been addressed here.
Yeah, in fact, section 385, 386, super priority for rescue financing and insolvency professional record. Fourth schedule of the ranks liquidated administrative fees, rescue financing and committee costs ahead of distribution from unencumbered assets. So it is addressed. National Chamber?
Honorable Chairman, I'm Charmika from National Chamber. We in general welcome the entire bill because it is heading towards a positive rescue first approach. But we also agree with a lot of the comments in terms of time bound and then tax provisions that this need to be revived on. Not sure, we've also got the invitation yesterday, just so that everyone knows.
Is an email hacked or something? Because
The
we
letter
sent
itself
it on the
dates yesterday.
24th.
So. But anyway, one more.
Wait. Unless your email is hacked. We have sent it to you on 24th Friday at 11:36 a.m.
Yeah, I guess.
Emails. Unless it didn't leave the building.
The outbox.
Could be. Apologies
go
on
ahead.
that.
Yeah.
One more observation that may not have been addressed, but we would also like to share is that does it have adequate data protection? Because usually when you get into these kind of processes, it's very obvious that debtors really try to default in such cases, and if those recoveries are prolonged, then whole process gets prolonged. So we completely agree with the timelines that was stressed here. So even data protection needs to be looked into it from that point of view.
Yeah, I mean, there is an issue there, a practical issue, Secretary, is that, while the law provides for various timelines, 30 days, 14 days, etc., once you go to the district court system, whether there is enough, free time for those people to deal with this, because there are, so many things to deal with in a district court. So whether the what you expect in the law, whether it can be actually implemented, and therefore if it is not implemented, that person would then be not in keeping with the undertakings taken. So that would become then another problem. So I think the practicality of implementing this law becomes a serious matter of concern.
Correct. What I meant, there is a lot of protection for the creditors, but the organization itself will have funds remaining with debtors. No, that's a part that we were talking about. Mainly. Anyway, maybe we can get some comments around that.
Yeah, the point is the company that is going through the bankruptcy has receivables.
Correct. And usually they get into default category very soon, moment they get to know that the company itself is in trouble. So so far as we've noticed, the provisions are not there to enforce
I think
that kind of payment.
it's a very valid point, a practical point. I don't know whether it has been considered. We'll make a note of that and we'll discuss it after the stakeholder consultation. Now let's move to the associations. Shall we look at the Sri Lanka Chamber of Small and Medium Industries?
ගරු සභාපතිතුමනි අපි මම සීනියර් වයිස් ප්‍රෙසිඩන්ට් චේම්බර් ඔෆ් ස්මෝල් ඇන්ඩ් මීඩියම් ඉන්ඩස්ට්‍රීස් මේ සාමාන්‍යයෙන් බින්දුවෙන් පටන් ගත්ත මිනිස්සු අද මහා පරිමාණයේ බිස්නස් කරලා කොයිඩ් පාස්කු පහරේ කොයිඩ් එක ඊට පස්සේ දිගට බාපු ප්‍රශ්න නිසා ඔබතුමාලා දන්නවා ඇති සාමාන්‍යයෙන් බිස්නස් කොහොමද මිනිස්සු රන් කරේ කියලා. කම්පිටිෂන් අඩුයි සෙනග ගොඩක් වැඩ කරනකොට. එතකොට දැන් කම්පිටිෂන් නැති නිසා මිනිස්සු හැම කෙනෙක්ම ගාමන්ට් ෆැක්ටරියක් වුණත් ස්ටිල් ප්‍රැක්ටිෆිකේෂන් එකට එනවා. හරි මේ මට වෙච්ච දේවල් ගැන මම කියන්නේ. මම බින්දුවෙන් පටන් ගත්ත මිනිස්සෙක් මට ලංකා බැංකුවෙන් දීලා තියෙන පොඩි මුදලක්. නමුත් අවසානයේදී 1 බිලියන් වෙනකම් මම ණය ගත්තා. ණය ගත්තේ ගෙවන්න පුළුවන් නිසා. නමුත් මේ ප්‍රශ්න ඇතිවෙන් පස්සේ රටේ ප්‍රශ්න තියෙනවා සාමාන්‍යයෙන් බැංක්‍රප්සි එකයි ප්‍රශ්න නිසා. අවසානයේදී කඩාම වැටුණා. කොහොම හරි ලංකා බැංකුව මට මගෙන් හම්බ කරපු නිසා මිලියන් ගණන් හම්බ කරලා තියෙනවා. මම බැංකුවට ණය නෑ. බැංකුව මට ණය තිබුණා. පාස්කෝ පාරෙන් පස්සේ මම බැංකුවට ණය වුණා. ඊට පස්සේ මම ගිය අවුරුද්දේ කොහොම ස්ට්‍රගල් කරලා ලංකා බැංකුව මට අතීත දුන්න නිසා මගේ බැංකු 5ක් තියෙනවා. බැංකු 5න් බැංකු 4ක් මම කොට දාගත්තා. කතා කරලා රිවයිව් වලින් කරගෙන ගියා. ගිය අවුරුද්දේ 500 million debts වලින් settle කරා. 1 billion එකෙන් 500 million debt settle කරා. අවසානයේදී HNB බැංක් එකෙන් මට රිවයිව් කරේ නැහැ. 2023 ලියුමක් එවනවා. ඔයාගේ මේ ඉඩම අපි ගන්නවා කියලා. ඉතින් කොහොම වුණත් අනිත් බැංකු වල මට සපෝට් එක දුන්නා. ඒ සපෝට් එක මත තමයි කරගෙන ආවේ. නමුත් දැන් මාව ඔක්ෂන් එකට ගිහිලා තියෙන්නේ පරාට කේස් එක හැටියට. දැන් පස්වෙන්දා ඔක්ෂන් කරනවා කියලා කිව්වා. මම අරන් තියෙන්නේ ඉඩමට විතරයි සල්ලි. නමුත් අපේ බිස්නස් එකේදී යාලා එක මුදල් දීලා තියෙනවා. නමුත් මගේ ඉඩම වටිනාකම මිලියන් 60යි. නමුත් දැන් මිලියන් 300ක් 400ක් වෙලා තියෙන පොලිත් එක්ක. ඒතර ගෙවන්න තියනවා කියන්නේ මුදල මිලියන් 200යි පොලිය 200යි. ඉතින් මේක යාලා කියනවා මිලියන් 300කට සෙල් කරනවා නම් ඔයා බේරන්න පුළුවන්. මම කිව්වා මට සතපාකත් එපා ඉඩම ඔයා ගන්න මම මේකෙන් ප්‍රශ්නේ මම බේරලා දාන්න. මොකද මමත් තව බිස්නස් කරගෙන යන්න පුළුවන්. දැන්ටත් මම බිස්නස් කරනවා. ණය බේරනවා. මගේ දැන්ට 100ක් වැඩ කරනවා. ඒ මිනිස්සුගේ පඩි ගෙවනවා, ටැක්ස් ගෙවනවා, ඔක්කොම කරගෙන යනවා. නමුත් මේ මත අනුව මේක මට ගිහිල්ලා මේක අඩුවට වික්කොත් කාට හරි ඉතුරු ටිකටත් මට නඩු දැම්මොත් මට ඒක ගෙවා ගන්න බෑ. මට මේකට උත්තරයක් ඕන මේ උගත් මහතුරුන්ගේ. කොහොම ස්තුතියි.
සංගමයක් විදියට මොනවා හරි ප්‍රකාශ කරන්න තියෙනවද?
අපි කියන්නේ මෙහෙමයි. මගේ 60ක් විතර සමාජිකයෝ මේ තත්ත්වෙම තමයි ඉන්නේ. මම උදාහරණයක් විතරයි මම මේ කිව්වේ. ඒ කියන්නේ ඉස්සර නම් 140ක විතර ලාභයක් තිබුණා බිස්නස් කරනකොට. දැන් ඒව නේ ඕවර්හෙඩ් එක කව කරගන්නත් බෑ.
නෑ මෙහෙම මේ ඇක්ට් එක ගේන්නේ පහුගිය වෙච්ච ප්‍රශ්න විසඳන්නනේ.
ඔව්.
ඒතරද ඔබතුමාලා සංගමයක් විදියට මේ ඇක්ට් එක ගැන අදහසක් තියෙනවද? මොකද පරාටේ ප්‍රශ්නය ගැන අපි වෙනම කමිටුව අපේ දැන් ෆොලෝ අප් එකක් තියෙනවනේ නේද? ඒක මෙතන කතා කරන්න බැහැ නේ
මම දැන් හෙල්ප්ලස්. මොකද හේතුව එයාලා කියනවා ඉතින් පස්වෙන්ද වෙනකොට මේක සෙල් කරේ නැත්නම් මේක ඔක්ෂන් කරනවා. එතකොට එයාලා සමානලාට බැංකුව අත්පත් කරගනි. ඊට පස්සේ ඉතින් යට මොනව වෙනවද දන්නේ නැහැ. නමුත්
දැන් පොඩ්ඩක් ඉන්න මහත්මයා දැන් මේක සාමාන්‍යයෙන් මිනිස්සුන්ට තියෙන ගැටලුවක්නේ. මේක මෙතුමා විතරක් නෙමෙයිනේ මෙතුමා එක්සැම්පල් එකක් හැටියට කියපු දෙයක්. එතකොට ඒක තමයි මම ඇහුවේ දැන් මේ චානක දිසිල්වා මහත්මයාගෙන් දැන් ongoing cases තියෙනවා. දැන් එතකොට මේ නීතිය යම්කිසි විදිහකට වෙනස් වෙනවා. එතකොට මේ නීතිය වෙනස් වුණාම මොහු වාගේ මේ ප්‍රශ්නෙට මැදි වෙලා ඉන්න කට්ටියට ඒ අලුත් නීතිය හරහා යම්කිසි විසඳුමක් ලබා ගන්න අවස්ථාවක් තියෙනවද කියන මම හිතන්නේ ඒක සාධාරණ ප්‍රශ්නයක්. ඔබතුමාගේ මං කලින් උත් ඒක විමසුවා ඔබතුමා.
Chairman, may I?
Just one moment, please. Yeah, I'm
Same
asking
line I
Mr.
want to ask from him whether this act supersede the Parate Act. That is what we have to look at it, I believe, because all the other things are. I'm representing the Ceylon Federation of SME, because if this act come into play, okay, whether this supersede the Parate law which is enacted, and the banks has taken that act as some people spoke, how they are implementing that act. Whether if it is comes to the second reading and it, as you said as a chairman, it will be enacted. Whether this act supersedes the Parate Act. That's what we have to look at it. And I think Parate has been a curse for this country for a longer time, only benefiting the banks. I just want to add that too. Thank you.
Mr. Chairman, as the President of the Sri Lanka Chamber of Small and Medium Industries, I would like to make this comment. Now with this new act coming in, how will it support the SME sector in Sri Lanka? Because SME is the backbone of any country's economy.
SME.
How will it support?
Chairman, now, the two things. Going forward, it's going to support SMEs for sure.
Yeah.
But I think what your question is,
Yes.
the ones that are in trouble.
Yes.
And that's
I mean, you know, let's not beat around the bush. This is a problem, whether we like it or not. This is a problem that's not going away. People are getting parate executed left, right, and center. Now, I think these are valid questions. I mean, you don't have to respond to it, but if you wish to, you can respond to it.
Yes, I can respond, and I would like to respond. I will try and address all the questions that were asked. May I answer in Sinhalese?
Please.
Yes. මේ සිංහලින් කතා කරපු මහත්මයා කියපු ප්‍රශ්නය වෙන අවස්ථාවේදී මේ නීතිය තිබුණා නම් ඔබතුමාට මේ නීතියෙන් සහනයක් ලැබෙනවා. හරි. අවාසනාවකට මේ නීතිය ඒ වෙලාවේදී තිබුණේ නැහැ. මේක යටතේ දැන් ඔබ කිව්වා බැංකු පහක් එක කතා කරලා ඒක සලස්ව ගත්තා එක බැංකුවක් කැමති වුණේ නැහැ කියලා. මේක යටතේ එවැනි අවස්ථාවකදී සියලු දෙනාම එකතු වෙලා තීරණයක් ගන්නවා මේ කොම්පැනිය එහෙම නැත්නම් මේ බිස්නස් එක ඉදිරියට ගෙනියන්න පුළුවන්ද බැයිද කියලා. ඔවුන් තීරණය කරා නම් යම්කිසි there are thresholds, I don't know the Sinhala word for it. තීරණ ගැනීමේ සීමාවල් තියෙනවා. ඒ සීමාවල් යටතේ ඔවුන් තීරණය කරා නම් මේක හසුරුවා ගන්න පුළුවන් කියලා සියලු දෙනාම මේකෙන් බැඳෙනවා. එතකොට එක බැංකුවකට විතරක් ගිහිල්ලා වෙනස් දෙයක් කරන්න බෑ 5 දෙනෙක් එකතු වෙනවා නම්. ඉතින් ඒ වගේ වෙලාවකදී ඔබලාට සහනයක් මේක යටතේ ලැබෙනවා. ඒක යටතේ ක්‍රියා කරා නම්. දැන් ඔබතුමාගේ ප්‍රශ්නේ උනේ දැන් මේක වෙලා උනාට පස්සේ මොකද කරන්න පුළුවන් කියලා. දැනට තියෙන නීතියක් පරාටේ නීතිය. ඉතින් පරාටේ නීතිය යටතේ යම්කිසි ක්‍රියාවක් කරා නම් ඒක නැවත ආපසු හරවන්න අමාරුයි. ඒක නෛතික ක්‍රියාවක්. ඉතින් ඒක අපහසු ක්‍රියාවක් වෙනවා. හැබැයි ඉදිරියට මේ නීතිය සම්මත වුණාට පස්සේ නීතිය ක්‍රියාත්මක වුණාට පස්සේ සම්මත වෙලා ක්‍රියාත්මක වෙන්න ඕනේ. ක්‍රියාත්මක වුණාට පස්සේ එවැනි තත්වයකදී බැංක් බිස්නස් එකක් ආපහු ප්‍රතිසංස්කරණය කරන්න ප්‍රොපෝසල් එකක් දුන්නා නම් යෝජනාවක් දුන්නා නම් ඒ අවස්ථාවේදී ඒක සම්මත කරන කල් නැත්තම් ඒක රිජෙක්ට් කරන කල් පරාටේ වත් මොනම දෙයක්වත් කරන්න බෑ. නඩු දාන්න බෑ, පරාට කරන්න බෑ, මුකුත් බෑ. හරි? හැබැයි ඒක අසීමිත කාලයක් නෙමෙයි. මොකද ඔවුන්ට තියෙන අයිතිවාසිකම. ඔවුන්ගේ ණය ගෙවිලා නැහැ. ඉතින් ඔවුන්ට තිබෙන අයිතිවාසිකම් අපි නවත්වනවා. හැබැයි නවත්තන්නේ සීමිත කාලයකට. මට මතක හැටියට මේකේ තියෙන දින 60ක්. ඒ දින 60 තුලදී මේ යෝජනාව ගැන සලකලා බලන්න ඕනේ. ඊට පස්සේ ඒකේ තීරණයක් ගන්න ඕනේ. ඒ තීරණය හරි මේ යෝජනාව හොඳයි අපි ඉදිරියට ගෙනියනවා කියනවා නම් අන්න එතකොට ඉතුරු කටයුතු සිද්ධ වෙන්නේ නැහැ. යෝජනාව ක්‍රියාත්මක වෙනවා. ඒ යෝජනාව හොඳ නැහැ මේක කරන්න බෑ වැඩක් නැහැ කියලා කියනවා නම් අන්න එතකොට ඒගොල්ලන්ගේ කටයුතු වලට යන්න පුළුවන්. එහෙම තමයි මේක සිද්ධ වෙන්නේ. එතකොට අර ප්‍රශ්නේ ඇහුවා පරාටේ නීතිය ක්‍රියාත්මක වෙද කියලා. right? පරාට නීතිය ක්‍රියාත්මකයි. පරාට නීතිය මේකෙන් අයින් කරන්නේ නැහැ. හැබැයි මේ නීතිය යටතේ යෝජනාවක් ඉදිරිපත් වෙලා ඉදිරිපත් කරා නම් ඒ යෝජනාව සලකලා බලලා එක්කෝ ඒක පිළිගන්නකල් එහෙම නැත්නම් ඒක ඉවත් කරනකල් ඒක කරන්න බෑ. ඒක කාල රාමුවක් අතරත සිද්ධ වෙන්න ඕනේ. කාලය දික් කර ගන්නත් පුළුවන් අවශ්‍ය නම්. හරි. හැබැයි ඒක ඉවත් කරොත් මේක වැඩක් නැහැ කියලා තීරණය කරොත් සියලු දෙනාම එකතු වෙලා ඒ කියන්නේ වැඩි කොටසක් එකතු වෙලා තීරණය කරා නම් ඒ කියන්නේ එහෙමනම් ඉතින් ඒක රිසරෙක්ට් කරන්න බෑ. ඒක ප්‍රතිසංස්කරණය කරන්න බෑ. ඉතින් ඒ අවස්ථාවකදී නැවතත් ඔවුන්ගේ ක්‍රියාවලියකට යන්න පුළුවන්. මේකේ විශේෂත්වය තියෙන්නේ අර යෝජනාවලියක් දීලා බිස්නස් එක ප්‍රතිසංස්කරණය කරලා ඉස්සරහට ගෙනියන්න පුළුවන් හැකියාව ලැබෙනවා. දැන් අපේ නීතියේ ඒ හැකියාව නැහැ.
බොහොම ස්තුතියි. දැන් කොහොම වුණත් මට සහනයක් ගන්න පුළුවන් ක්‍රමයක් කියන්න පුළුවන්ද? ඒ කියන්නේ මම දැන් හෙට යනවා සාකච්ඡා කරන්න. හේතුව මට කලක් දෙන්න කියලා. මොකද මම ඉඩම විකුණන්න බලන්නේ නැත්නම් ව්‍යාපාර කටයුතු කරන්න යන්නේ. මොකද හේතුව මම බින්දුවෙන් පටන් ගත්ත මිනිහෙක් 1 බිලියන් අරගෙන දැන් 500 මිලියන් සැල් කරලා තියෙනවා. තව දුරටත් ගියන්න පුළුවන්. මේ ප්‍රශ්න නිසා ඇතුළත තමයි කරගෙන යන්නේ. ඉතින් සමහර වෙලාවට බොහොම අමාරුවෙන් මේ කම්පැනි රන් කරන්නේ. වෙලාවට මිනිස්සුන්ගේ පඩි ගෙවන්නත් බෑ. ඒකත් බොහොම අමාරුවෙන් ගෙවාගෙන යනවා. දැන් හරි ආසයි ඉතින් ලංකා බැංකුවත් උනත් අනිත් බැංකුව උනත් සපෝට් එක දෙනවා උදව් කරනවා. HNB විතරයි උදව් කරේ නැත්තේ. ඉතින් අර 5 දෙනා 4 දෙනාත් එකතු වෙලා ඔබතුමා කිව්වා වගේ අපිට පුළුවන් නම් සාකච්ඡා කරගන්න සමහරට ගොඩ දාගන්න බැරි කමක් නෑ පුළුවන්. මොකද අපේ නොලෙජබල් තියෙනවා.
Yeah.
Mr. Chairman, let me tell you, I think it is a welcoming act especially for the benefit of the SME sector. I think that is supporting. We are very much with them, with it. But we have to, as he has a case, right? So there are many SMEs in that scenario. If you can think of it and think of an amicable solution, we would welcome. Thank you.
බොහොම ස්තුතියි. ඒක තමයි මම ඇහුවේ ඇයි අපි අවුරුදු දෙකක් ප්‍රමාද වුණේ කියලා මේ නීතිය ගේන්නේ. 24 ජූනි මාසේ සම්මත වෙච්ච එක 26 ජූනි තමයි මේ එන්නේ. හරි ඒ අවුරුදු දෙක ඇතුලේ බොහෝ දෙනෙක්ට මේ ප්‍රශ්නෙට මුහුණ දෙන්න සිද්ධ වුණා. ඉතින් දැන් ඒකට කරන්න දෙයක් නැහැ. හැබැයි දැන් ඔබතුමා කියපු දේ මට තේරිච්ච විදියට මේ process එක යනවා නම් ඒ process එක දැන් යන්න වෙනවා. මේ process එකෙන් අලුත් process එකට යන්න ක්‍රමයක් මං හිතන්නේ නැහැ තියෙනවා කියලා. ඉතින් ඒක වෙනම නීතියක් ගෙනල්ලා ස්පෙෂල් මොකක් හරි මට තේරෙන්නේ නැහැ. ඒක යම් විදියකට එමෙන් කරන්න පුළුවන් නම් එහෙමනම් ඒක ආණ්ඩුව පොලිසි එකක් හැටියට බලන්න සිද්ධ වෙයි. නැතුව මේ නීතිය අර නීතිය සුපර්සීඩ් කරනවා කියලා එහෙම හැකියාවක් තියෙන බවක් මට ඇඟෙන්නේ නැහැ.
මම පොඩක් පැහැදිලි කරගන්න හැවුවොත් පරාටේ දාලා නැති බැංකුව එක්ක ඩිස්කස් කර ඉන්න කෙනෙක් හිටියොත් මේකෙන් යන්න පුළුවන්.
මේකෙන් යන්න.
හරි ඒක තමයි. පරාටේ දාලා තියෙනවා නම් දැන් බැංකුවත් එක්ක ආයෙ negotiate කරගෙනම තමයි යන්න වෙන්නේ. හරි නේද?
මොකද පරාටේ නීතිය බොහොම විශේෂ නීතියක්. ඒකෙන් ඒ අදාළ ඉඩම එහෙම නැත්නම් අදාළ දේපල අයිතිය ලබා ගන්නවා බැංකුව විසින්. එහෙම නැත්නම් අයිතිය වෙන එක්කෙනෙකුට දෙනවා. ඉතින් ඒ අයිතිය දුන්නට පස්සේ වෙන එක්කෙනෙකුට ඒක නැවත අයිතිය ඒක නැවත ආපහු අර ණය තත්ත්වයට ගන්න හැකියාවක් නැහැ. එහෙමනම් අර බැංකුවෙන් අයිතිය අරගෙන එහෙම නැත්නම් තුන්වෙනි පාර්ශ්වයට වික්කනම් එයාගෙන් අයිතිය අරගෙන නැවත යන්න ඕනේ. ඉතින් ඒක අමාරු කාර්යයක්. ඒක බොහොම නෛතික ක්‍රමයකින් යන්න ඕනේ කාර්යයක්.
හරි මම හිතන්නේ පැහැදිලි. ඔව් honorable.
Does that mean that the Parat execution has to be completed, or if, let's say, the board has taken a resolution but they have not really enforced that resolution? What is the standing then?
Well, what the law says, what this says, I think it's in the section 196 onwards in this. All enforcement action must stop. Okay. So if you have done a resolution but not sold,
right,
you can't sell.
Okay.
Once the rescue plan is submitted, typically if banks, if there are 3 banks, one bank doesn't agree, is there a process of appeal so that can be, if banks refuse? And if the parties who are present in the rescue plan is interested in, trying to go to another body to try and get this addressed.
Now, the methodology which is given here, I mean, that is why you have these insolvency professionals. The methodology given here is that the rescue plan must come with the blessings of an insolvency professional. So, in other words, you are actually presenting a workable plan. This is not a plan in the sky. It's a workable plan. Now, if a workable plan is presented and that is accepted by a majority of the people, I think there is a majority of the creditors, there are thresholds which are there, my recollection is about 60%, then everybody becomes bound by that. But on the other hand, if it is rejected, if the majority feel, no, this is not going to work, then one has to go on the basis that the plan is not a workable plan. Then you can present another plan. Or the bank can take over, the banks or the creditors can take over and present a plan. So, or
Time frame of 2 months.
All within the time frame of 2 months, or extended by them, they can extend. So the law compels the stoppage or the moratorium as we
That's a
call
time-bound,
it, is
it was
for a
mentioned.
is for a time period.
දැන් මෙහෙමයි අපි මේක ඉතාමත්ම ධනාත්මක දෙයක් පරක්කු වෙච්ච එක පිළිබඳව තමයි ගැටලුව තියෙන්නේ. නමුත් දැන් මේක ඇක්ට් එක පාස් වෙච්ච පාලියට රෙගුලේෂන් හැදෙන්නේ නැහැනේ. ඉන්සොල්වන්සි මේ මොකක්ද ඒකට කියන්නේ මේ ඔතොරිටි එක හැදෙන්න එපා. ඔතොරිටි එක හැදෙන්න ඕනේ. ඊට පස්සේ ඉන්සොල්වන්සි ප්‍රැක්ටිෂනර්ස්ලා හදා ගන්න ඕනේ. ඊළඟට ඔෆිෂල් රිසීවර්ස්ලා ඔෆිෂල් රිසීවර් හැදෙන්න ඕනේ. ඊට පස්සේ දිස්ත්‍රික් අධිකරණය මේක ක්‍රියාවලිය අර කවුද කිව්වා වගේ ඒ කට්ටිය පුහුණු කරන්න ඕනේ, ට්‍රේන් කරන්න ඕනේ. මේ සියලු දේ සිද්ධ වෙන්න ඕනේ. එතකොට මෙතන ඊළඟට තියෙන්නේ ඔබතුමන්ලාගේ අතේ තමයි මේ වැඩේ තියෙන්නේ. පාර්ලිමේන්තුවෙන් කරන දේ අපි කරන්න. පාර්ලිමේන්තුවේ මේක සම්මත වෙච්ච පළියට මේක මහ පොළොවේ ක්‍රියාත්මක වෙන එක ඩිලේ එකක් තිබුණොත් ඒක ඕගොල්ලෝගේ අතේ. අපේ අතේ නෙමෙයි. අපිට පුළුවන් නීතිය සම්මත කරන්න. හැබැයි දැන් උදාහරණයක් හැටියට ගන්න මයික්‍රෝ ෆයිනෑන්ස් මොකක්ද ඒක මයික්‍රෝ ෆයිනෑන්ස් රෙගියුලේටරි ඔතොරිටි කියලා එකක් අපි පාස් කරා. කැසිනෝ රෙගියුලේටරි ඔතොරිටි එකක් කියලා අපි පාස් කරා. හැබැයි කිසිම දෙයක් වෙන්නේ නැහැ. මොකද ඒවා ඉම්ප්ලිමන්ට් වෙලා නැහැ. රෙගියුලේෂන්ස් හදලා නැහැ. ඉතින් මම කියන්නේ ප්‍රැක්ටිකලි අපි මෙතන දකින දේවල්. ඒ නිසා අපිට පාර්ලිමේන්තුවේ නීති සම්පාදකයෝ හැටියට මේවා තේරුම් අරගෙන ප්‍රශ්න තේරුම් අරගෙන සටන් කළා මේක ජයග්‍රහණයක් කියලා මම දකිනවා. හැබැයි ඊළඟ ස්ටෙප් එක නිලධාරීන් අතේ තියෙන වැඩ.
සභාපතිතුමනි වින්දිතයක් හැටියට මට දෙන්න පුළුවන් සොලියුෂන් එක මොකක්ද?
සොලියුෂන් එක තමයි මේ කට්ටියව ඉක්මන් කරවන්න. ඔව්. No, yeah, that's it. Right? We have time. We got to move. Yeah. So now ඊළඟට එහෙමනම් මේකේ අනිත් පැත්ත banking association said that they have no problem, so therefore we are assuming that the banks are very happy that the Parate execution is getting stopped. But the banks were the ones that were unhappy, no? Banks were the ones that were saying, no, Parate has to go on. Now they are saying the Parate will be stopped. The banks have no qualms about that. Am I?
No, banks are not here even, so.
Yeah.
No, Bankers Association is here, no? Bankers Association is here.
They are quite happy with Parade.
That we know. That's why the law-
That now what the Mr. Chanaka De Silva is saying is completely contradictory to the position that the bank has been holding all this time. So I'm asking you because we gave you the chance first. You said you have no comments to make.
No, Chairman, we will give written comments because we have already given comments as well. So we during give us a few days, so we will make the
Sure.
major observations that you want to present, please.
Right, thank you very much. Then the Finance House Association, Leasing Association, those are the two that's remaining.
Excuse me.
I'm sorry. Other chambers?
Yes.
Sorry, please. Yes, Ceylon United Business Alliance, Mrs. Abe Sundara.
Thank you, Chairman. It's a great honor to be here. I believe this insolvency law is not SME beneficiary at all. This law was really passed during the previous regime to attract FTEs, and then it was a credit-driven insolvency. That's what I mean. Looking into everybody speaking on behalf of this, I believe the SMVs don't benefit much out of this. And like Mr. De Silva said, he thinks this is a great thing for the SMB organizations, but I believe it is not, because it only has a 60-day validity period in not going ahead with any sort of action. So what can a SME organization do within 60 days? This is incredibly, insanely not appropriately. I believe this law, if this is being brought into act, SME organizations are going to suffer tremendously, because what is going to happen is this is a multinational protective insolvency law that I believe. Because if you were to look at the taxations, if you were to look at whatever that is being written in this, this is not SME. So I believe if this law is going to be brought into action, there should be a segregation for a different amendment done for SMEs separately. Otherwise, we would suffer tremendously, because this would benefit all small companies, medium rate companies, to be acquired and disposed into bigger organizations, what is exactly right now happening. So it is going to be a chain-oriented beginning, because smaller companies will be acquired by by the banks and given to bigger companies. So this is a dangerous situation. So I believe this act should have a separate, total separate.
I'm going to do two things. One is there is a bespoke arrangement for SMEs. That is the question that I asked at the very beginning from the Mr. De Silva. So there you have the individuals, you have the corporates, and then you have a bespoke arrangement for the MSMEs. So the question I asked was originally, who determines, right? Whether this goes under corporate or whether this goes under individual. So when you say there is the MSMEs have been ignored.
I'm not saying, Dr. Chairperson, the MSMEs have been ignored. I believe the MSMEs are not properly taken into consideration. If you were to evaluate the MSME cycle, Mr. Chairman, it is totally different to what the Act will be protecting the company, because our cycle is a very dangerous cycle, because we totally depend on funding from the banking institutes. So our collateral is not much. So our collateral is very limited. The exposure, funding given without exposure, of course, any banking institution wants to reform it and try, because they don't have to obtain anything. But if there is a collateral, first given chance, they would go into more than resolving it, obtaining, trying to go act the Parata Act. So what I'm trying to say is, if you were to look at the SME...
But Mrs. Abesundara...
It has to happen through the institution or not?
Mr. Minister, yes, it would happen through the institution, but if you were to really go through the
Now
Act...
we don't have any barrier, because the banks will decide. Now after this, less than 50 million, there's an option of waiving also.
Didn't he mention it is only 60 days?
Yeah, it has to be time bound. No?
Yeah, so time bound of 60 days, it is adequate enough for a companies of SME magnitude. If it's a multinational companies, yes, there are multiple companies to acquire it. They are willing to, funders will come forward to rescue. Rescue policies can be easily made. But when you look at SME organizations, you have to evaluate long-termly. For them to be rescued within 60 days is not an easy target and a task.
I think there's a misunderstanding.
No, Mr. Chairman, if you were to read and act, I don't know. I have not fully gone through it, because I also didn't have adequate time, because I was out of the country. But the little I read through, and
so let me clarify this. Let us all get clarification, because you are raising a very important point. And
very important, Mr. Chairperson. You please go through.
You're a vocal sort of. You've been fighting for this. And
I have been fighting, and this
so
act
we understand
within 2024 with Mr. Rajapaksa, former Justice Minister, was brought upon with us. We got this act done, but it was not prepared in this manner. That act was prepared for more protection for the SMEs, but this has not much. So, Mr. Chairperson, I would really appreciate.
So this, I think the issue is with 60 days. No, the way I understand is that you are given 60 days in order to get to the next step. And that next step, if you are unable to get to the next step in 60 days, the court may extend that 60 days to another 60 days.
No, that was not mentioned. He said when the bank has
The creditor will extend it for another 60 days. But 60 days is set.
So whatever the period, they can go on extending as long as they get the... But it must be done with consent.
Decision.
But the creditor has to
See,
concern with the creditor.
You must understand, these are people with rights. Creditors have rights. You are taking away the rights of the creditors for a period for the benefit of the debtor by this law. That is why the banks oppose the right to give up their parate rights. right? So therefore, there must be a balance between the two. It can be 60 days. If the legislature feels it should be 90 days or 120 days, so be it. But there must be a balance.
But
You can't
but,
take away that right without
But
their
is there a
consent
specific
for a
time
long
period that
period.
MSMEs will prefer?
No,
apart
yeah, honorable member, I would say that this policy should be adequately, the government needs to intervene with some sort of a body where this, if MSME organizations are to be brought forward with this, this sort of thing, because there are willful defaulters and defaulters due to circumstances. So these are, Mr. Minister, can I just please? So this has to be taken into consideration. Willful defaulters, the banking sector knows. But if it's defaulters due to circumstances, then it has to be taken into a completely different body, because these circumstances defaulters can be rescued very easily. But if they don't have the adequate facility of collateral being given back again to the bank. Now, let me tell you a very small incident. A very, very well-functioning companies, if your MPL, when you go into the crib, and if the crib is being even a little bit distracted, you could never get working capital done. So, I mean, you are a fantastic paymaster. You are paying your loans on time, but sometimes there have been incidents, maybe 30 or 60 days. But if it's been highlighted, you are on 60 days MPL, not for big, you're not defaulting.
Yeah, but then that
still,
is outside this, Mrs. Abesundar, that's outside this scope.
no, Mr. Chairperson, this adequate time frame is not enough.
Yeah, so that is what.
So
that's
that's what
another
I'm
matter.
trying to say,
Yeah,
Mr.
that, yeah, that is, we are trying to find it in the legislation that you said, you know, it is up to us to determine the
I think what she's basically
so-
saying is
so it is
MSMEs can't be
subsection-
rescued from this law.
It is
It is
subsection.
not easy,
Just one moment.
dear member.
One moment.
On-
This is on, this subsection, section 41, subsection 1. Debtor protection moratorium commences when a court makes a debt protection moratorium order. 2. Subject to subsection 3, a debt protection moratorium continues for 60 days from the date on which it commenced under subsection 1, unless, and there are some conditions. So, Mr. De Silva is correct. I mean, it is up to the legislature to determine whether that 60 days is right or whether it has to be 30 or 120 or 180. So, I agree with Mrs. Abesundara that, you know, you need to be able to take into consideration the circumstances of those affected, while agreeing with Mr. De Silva that you are taking away the right of the bank to para execute the mortgage that they have, right? So I think it's a balance, and it is not up to me, it is up to the government in this case, and MOJ particularly, to amend the 60 days if you wish to.
Chairman, it's normally now at the moment, as I'm a restructuring guy, and I think I have the license to do that. I've been doing so much in the country. Now I have dealt with a lot of banks, and this proposal came to former President RW to in one of our organization presented. Honorable member was there at that time. We had made some comments, but this 60 days, the 60 days as an issue as well, as she rightly said so, because at the currently default comes within the 90 days. If you are not paying within 90 days only, then the circle comes. That's what the crib says. You are failed to make the interest payment or capital. So the crib,
Mr. Raghavan, it is very clear in the law. It is 60 days. It can go up to a maximum of 90 days, and it can be it can be extended for 4 times.
They can
So,
decide.
Mrs. Abesundara, what you are saying is you have 90 days, that is 3 months into 4 is 12 months. So, if there is concurrence, if you agree, then you can extend this for 1 year.
Chairman, I think we are missing the substance of the act itself, right? Now this act has brought in to save the asset, right? Asset for the interest of the country. Oh, you know, the economy. That is where it still starts. So when somebody goes into a level of liquidation or discussion, bank also gives a fair enough time, right? I think more banks have given more than 3, 6, 9 months, then only this discussion will come. So your point of applying for bankruptcy is the point that from there onward 60 days is what's been discussed. So obviously there is a room of, you know, restructuring your organization for a longer period of time. So this is not that's going to happen. I think what we need to distinguish is what is this law, and I think we are now mostly discussing an incident that happens like the Easter attack or some kind of a crisis. How do we act is a different structure. I think those two cannot be discussed in the same act itself.
But is there accommodation in the act for a situation like that?
This issue really occurred after the Easter attack,
Exactly,
bankruptcy,
exactly.
Corona, because if you were to evaluate in 2019 and 2019, our
Now imagine if we had that,
our
this-
MPL level was only
So if
680
imagine
million.
If this was there by
So-
2019, we wouldn't have much of these problems as well.
Yeah, so,
but the 2019 is an incident, no. Now think of a normal situation. People go into bankruptcy in normal situations also. Right? So the problem that you are probably asking is how do we
I'm not asking that, Mr.
how do you resolve a crisis situation?
So I'm not asking how
is
do
there,
we...
is there space in the act to get into a crisis situation like that when there's
That's not
because
there.
because this is a bit of it's a turbulent time, and I think that
Let me answer it this way, and I will also try to answer the question that was raised by her. We are not dealing with non-performing loan scenarios or default scenarios in this law. That is determined by the banking provisions and the classifications which are given by the central bank. They tell you how to deal with a non-performing loan or to consider
part of the
a
banking
loan
system.
being performed. That's a completely different question.
right.
This deals with the making of a proposal for restructure. When a proposal for restructure is made, that from the making of that proposal, you have a moratorium of 60 days, whether it be personal or whether it be corporate. During that period, the creditors have to get together and discuss this. Right? Now, once they discuss, if there is merit in the proposal, or a majority agree that there is a merit in the proposal, then the restructuring process can go longer. The proposal stage can go longer. Because putting a restructuring proposal in order can't work in 60 days. But on the other hand, you can't also permit a situation just to be for an entity or a debtor to be coming up with proposals and
Just to
proposals
drag
and
it.
proposals which
Yeah.
have no merit.
Yeah.
So if the majority don't agree that there is merit in this, then of course the proposal will come to an end. But on the other hand, if the majority agrees that there is merit, then the proposal can go forward. They can adopt it, they can extend the time for consideration, they can amend it, they can appoint their own administrators to do it. So it can go forward on that basis. But for that, the creditor whose rights are taken away for that period has to be involved. So the mandatory period is what we are talking about. That 60 days is the mandatory period.
I mean, it boils down finally to the legislature, right? I mean, if you want to change it, you can. I mean, it's a subjective thing. Why 60? Why not 45? Why not 90? Yeah, so I mean, somebody has to make a call on it.
Can I just ask a question? With your knowledge, Chanaka, that you've gone through this process, what is the period in India? What is being used? Because that's one of the peer countries that we have the similar type of problems.
I can't tell you the specific period.
It is 180 days or...
But these periods are not long.
These not...
Periods are not long.
But India gives the initial period of 180 days. That's the background that we should be looking at. I mean, you're only proposing, so it's the government to take a call.
Yes,
That's what you
it's
say.
It's a government to take a call.
Yeah, the way things are going, I think the banks also may come under this. The way
Yes,
the
see,
banks are being hacked.
Yeah.
You will have the banks coming to be protecting.
Yes,
so
because the moment you
it's
do
a
that,
dual approach these days. So.
the moment you do that, right, you are also putting a fetter on the banks and other institutions which also handles public money,
Yeah.
right, from exercising their rights.
Yeah, we are.
Mr. Chairman, just one more thing.
Yeah, we
Very
are
sorry,
running
I
out of
understand.
time, yeah.
Is there a possibility where there could be a segregation done for the SME on an insolvency on this act?
I mean,
Separate.
it is, anything is possible.
I'm
The
just
law is
only,
made in this building, right? You want to make it 24 months, you can do it. Right? So it is possible and nothing is impossible. Right? We make the law. Right? So therefore, but then there has to be some logic, right? And some balance.
There
And
are
what
absolute rights, don't
yeah,
there?
yeah. So
Is
that is
there-
what you are saying, what is
No,
that balance?
Can we also come out with some proposal where you all could look into it?
No, I can't, MOJ can.
I think it's possible now if you really go through that. There's a whole heap of MSME section, and in that it has all these structures. It's probably dates and thresholds. It says if you are below 50 million, it can be written off also. There's a provision like that.
Yeah.
So if those are not enough, we can discuss. But the Act has enabled a specific section for SMEs, MSMEs. So I think that is what we need to look at detail. Maybe you guys can do it, and then bring more proposals to the Ministry of Justice.
ගරු සභාපතිතුමනි
හරි දැන් අපි
නෑ මගේ අන්තිම ඉල්ලීම
මට දැන්
මම
වෙලාව
දැන් මේ ප්‍රොපෝසල් එකේ මම කියන්නේ මේකයි සෙන්ට්‍රල් බැංකින් මෙතන ඉන්නවා නම් අනිත් බැංකුව හතරත් එක්ක එකතු වෙලා මාව බේර ගන්න පුළුවන්ද කියලා අහන්න. එච්චරයි.
ඒක පුද්ගලික ඉල්ලීම මම මෙතුමා දිගින් දිගට මේ ඉල්ලීම කරා මම දැන් මට හරි that's anyone else that we didn't speak to? We spoke to everyone. I just want to come back to Mr. Vijay Singh one last time because what Mrs. Abesundara was saying is this has been created for this to bring in capital to restructure big companies as opposed to the MSMEs, and those guys are actually left in the lurch. I mean, is there something that you want to add to that?
Honorable Chair, capital.
No, that's yeah. Go ahead.
Capital is available across the entire spectrum, whether it is MSME or large-scale investors. But the point is, often looking at individual MSMEs can be a tedious process because you have to put the same amount of time and effort of a large-scale restructuring as well as a small-scale restructuring. So that's where the insolvency committee or whatever that's called in the law would have to look at segregating and aggregating similar types of MSMEs.
So that is what she was talking about, aggregating.
Precisely.
Right,
So
she was
that
talking about aggregating a whole bunch of MSMEs and then sell it off to some other guy.
or
At
look
the
at
end, it's a sell-off.
Yeah.
Of course.
No, that's-
Somebody has to bring equity.
No, that's my point. That's my point.
correct.
Yeah.
And that's why, this, Honorable Member, the parallel to that are funds. Now, at the moment, aggregation of funds is discouraged via our tax legislation in the country because of lack of limited liability partnership legislation. But so often there are big, what we call family officers in Sri Lanka. Now, I don't want to mention family names, but they can be as large as $100 to $200 million where they are investing in treasury bills, stock markets, etc. Now, we can play a role in advising these family officers in Sri Lanka to allocate 5%, 10% of their capital to look at resuscitating some of these businesses because they will bring their corporate expertise as well. But often looking at the MSME sector becomes rather problematic unless there is a framework or the preliminary data is available through some independent party. So that's my sort of comment.
Actually, now
yeah.
Thilan, you're just mentioning you're externalizing a local debt. How will the central bank come in to look at that? Your repayment out, these are domestic debt. Now you're going to externalize it.
Correct.
When
No,
you
I'm not.
externalize
I'm talking
the
of even
repayment
family
and all.
officers that are based in Sri
No,
Lanka.
that's you're tapping the local.
Correct.
exporters.
But if you're bringing from
I'm talking
overseas
if
sources,
you sell your debt out to
Honorable
external-
Member, one of the key things we have to look at is land ownership laws in the country.
Yeah.
So because
Leveraging that.
yeah, if it is a minority stake, there is no problem, right? The majority locally owned means if there's an underlying land assets within the balance sheet of that company being restructured, it can be held by foreigners as long as it's a minority stake.
But you
the moment you go majority, that's where I feel that at least legislation you should write into that an asset going through this process, that foreigners even temporarily looking at owning land freehold till such time it's converted into a leasehold or whatever. I mean, I don't want to venture into the politics of this. Because we are restructuring the enterprise, we must give legal provision. Now, the SDP Act, Honorable Member, I don't know whether the new act gives provision for foreigners to own land if it comes under the SDP law. I'm not familiar with the new whether there's a new amendment to that. So similar consideration would have to be given on land ownership.
Right. I think we've had a very, very fruitful discussion. එක පොයින්ට් එකක් දැන් අර මේ ඉන්ට්‍රස්ට් රේට් ගැන කතා කරනකොට මෙතුමා කිව්වා මේ 100ට මේ 25ට 30ට 40ට ගියා කියලා. ඒතර එතන ඒ කොන්ෂස් ඩිසිෂන් එකක් තමයි මේ ෆික්ස් රේට් එකකට යනවද ෆ්ලෝටිං රේට් එකකට යනවද කියන එක. අපි එතකොට ඒකත් මම හිතන්නේ
ඒක සභාපතිතුමා දැන් තියෙන්නේ අපි ගියපු ඇග්‍රීමන්ට් එක අනුවනේ අපි ගිහිල්ලා තියෙනවා ෆ්ලෙක්සිබල් රේට්
ඒක තමයි මම කියන්නේ.
එතකොට අපි ඉස්සරහට බලන්න ඕනේ නම් MSMEs වලට මොකක් හරි ප්‍රොටෙක්ෂන් එකක් තියෙනවද threshold එකක් දාලා හරි බ්ලොක් කරගන්න. ඒ කියන්නේ එහෙම නැත්නම් නවත්ත ගන්න හරි ඉන්ට්‍රස්ට් එක එක්ස්කලේට් කරන එක නවත්ත ගන්න හරි බැංකින් සෙක්ටර් එකත් එක්ක කතා කරලා කරන්න වෙනවා. දැන් මේක වෙලා තියෙන්නේ
දැන් ෆ්ලෝටිං රේට් එකට එග්‍රී වුණා.
ලොකුද කියලා නෑ ෆ්ලෝටිං රේට්
එග්‍රී වුණා නම් ෆ්ලෝටිං රේට්
ඔබතුමා
එක
කියන කතාව ගොඩාක් හොඳයි. මොකද ලෝකේ අපේ නේබරින් කන්ට්‍රීස් ගත්තාම ඉන්දියාව, වියට්නාමය, තායිලන්තය, මලේසියාව MSMEs වලට not protection net. They have separate interest rates, separate adequate systems being built for their uplifting of the organizations.
Right. Okay. So now, Hemanan, thank you very much, Mr. De Silva, for participating on the invitation of the Secretary of the Ministry of Justice. It was very helpful. And I think this turned out to be much more than what we expected. I think there was a lot of good ideas that came up. And I think there is scope for MOJ also to think about amendments to the legislation, perhaps some committee stage amendments. And I think something that we debated towards the end is the number of days allowed. That is something perhaps a very political one, which needs to be considered. What we will do is we will take into consideration all that was mentioned here, and we will submit it to MOJ and to the Ministry of Finance, so that in the next few days, when can we do this? Can we do this by tomorrow? We'll try to summarize everything by, unfortunately we don't have AI here. If we did, we could have done it much sooner. But we'll send it to you as soon as we possibly can, so that you can use it for debate and discussion inside and make any relevant amendments.
Harsha, can I?
Yeah.
The Justice Ministry or Chanaka, could you tell us whether there can be a fast-track court for this? Because sometimes when it goes before a court, those judges may not know the commercial sense. Like commercial courts being brought into existence, can there be, you're looking at the district court now, so whether there can be dedicated court and dedicated judges for this purpose, because otherwise it will be of no purpose at all, because they'll postpone the case till you get a knowledge. Yeah, you have a fast track court for dedicated court.
Yeah, Honourable Member, the Honourable Chief Justice is in the process of establishing special courts based on the needs. So this is one of the things which we can promote, and he will certainly understand. Depending on the discussion that we had today, we do understand that it's time consuming when you take the volume of work in the district court. So we will certainly follow it up.
So can that be brought in the legislative process?
Not regulation, perhaps.
No, not the regulation, in the law itself, that it goes before such a court.
Then that's a big decision.
You understand the situation, practically how it will be. Because it's going to be another piece of legislation without any practical purpose.
But Honorable Ravi, but it will delay it, no?
No, it just only to incorporate the...
Can I give a response to that? There are negatives and positives of that. The negative is that you create a new court, you give them work, that work may take a long time to develop. What do you do in the meantime? So the process that has been used is, if you look at our commercial courts, from time to time, when there is relevant material coming, for instance, company work goes to the Commercial High Court, IP work goes to the Commercial High Court, arbitrations go to the Commercial High Court, admiralty matters are in the Commercial High Court. So very specific things go to the Commercial High Court. If in the Commercial High Court you need to have a separate court dealing with a separate subject, I'm sure the Honorable Chief Justice will look at that. So that is a more efficient way of dealing with it, depending on how it comes forward. That is, so with the development of it, you can do that. The second thing we need to understand is, this needs, particularly the personal aspects, need to be decentralized. So they must be available to the people at the lowest level with easiest accessibility. So that needs to be looked at. So if everyone is to come to Colombo, that is not going to help them. So that is an aspect that we have to look at in relation to that. The third thing that we did take into account in relation to judicial delays is that in most of the instances, if everybody is agreed, you don't have to go to court. Things can be sorted out outside.
Just like
the whole process can go
arbitration
outside.
process.
Yes. But you go to court only if there is a difference of opinion, if there is a dispute. You have the ability to go to court and get an order. So unlike in the current scenario, you're not compelled to go to court.
Okay.
Right?
So it's provided here in the law?
It is provided in the law.
What's the section, Chanaka?
It is not a single section, it is everywhere. So it gives you the ability to do things, and where you need to go to court, you can go to court. That's how it is structured.
All right. Thank you very much. Let me once again thank KPMG, Sri Lanka Chamber of Small and Medium Industries, the National Chamber of Commerce, FJ&J Diseram, Nithya Partners, Sri Lanka Banks Association. Unfortunately, we couldn't get to the Finance House Association of Sri Lanka and the Leasing Association of Sri Lanka. So if you don't mind, if there is anything that you would like to add, please send it to us in writing. The Chartered Accountant, CA Sri Lanka, Verite Research, we couldn't get to you. Also, if you have anything, please send it to us. Ceylon Federation of MSMEs, Ceylon Chamber of Commerce, Advocata Institute, Ceylon United Business Alliance, and TW Corp Private Limited. So thank you. It's been very useful. I would request the government officials to stay for a little longer so we can sort of finalize things. Thank you for your participation.